Good evening, everyone. Welcome back, future lawyers, to day 13 of our bar review. We are now 176 days away from bar examinations. Today, we are tackling a very crucial procedure mechanism, the principle of judicial hierarchy. We will learn that even if the Supreme Court has the power to issue a writ, you cannot just knock on its doors immediately. There is a strict sequence and order to how cases are elevated. But before we delve into the rules today, let us reflect on our guiding verse from Exodus chapter 18, verses 22. Have them serve as judges for the people at all times, but have them bring every difficult case to you. The simple cases they can decide themselves. Long before modern procedural rules, this verse established the very first judicial hierarchy. Moses was drowning in a backlog of disputes. His father-in-law advised him to appoint lower judges to handle the simple, factual cases, reserving only the most difficult legal questions for himself at the top. This perfectly captures the essence of our topic today. The Supreme Court is the Moses of our judicial system, a court of last resort that relies on lower courts to filter the facts. Now, before we jump into the hierarchy of courts, let us first resolve the bar questions I left you with back in day 10 regarding the liberal construction of procedural rules. Here is the question we left hanging 3 days ago. Attorney Cruz missed the deadline to file an answer because of poor office management and heavy caseload. When challenged, he simply invoked the magic words "liberal construction." If you were the judge, would you allow this? Let us reveal the suggested answer. For this, we will use the beer method of answering. If you wrote this down, give yourself full points. First, the binary. No, I would not admit the late answer. Second, the enabling law. Jurisprudence provides that the principle of liberal construction applies only to proper cases and under justifiable causes, and cannot be used to excuse an utter disregard of rules. Third, the evaluation. Here, the principle of liberal construction was applied by Attorney Cruz just to excuse an utter disregard of rules by simply invoking Section 6, Rule 1 of the Rules of Court without providing a valid excuse. Furthermore, the heavy caseload and poor office management constitute inexcusable negligence rather than a justifiable cause. And finally, the resolution. Thus, if I were the judge, I would not admit the late answer based on the principle of liberal construction. Notice how beautifully this evaluation waives the objective facts, the heavy caseload and the poor office management. Two definitely prove to the examiner that his actions were inexcusable negligence and not a justifiable cause. By doing this, you leave no room for doubt. Now, let us proceed to today's main topic. To properly digest the hierarchy of courts, we will use our four-level analytical framework, the Beer Syllabus. First, the big picture, placing us within the syllabus. Second, the essential pillar, where we define principle and its application to concurrent jurisdiction. Third, the elemental principle, where we explore the strict exceptions that allow direct resort to the Supreme Court. And finally, the root level, looking at the landmark Supreme Court ruling that acts as the ultimate filter for these exceptions. For our big picture, we are at the tail end of the general principles of remedial law. Understanding the hierarchy of courts is vital because it establishes the orderly mechanism by which litigants seek redress. Even if multiple courts share the same power to hear a petition, this framework dictates the exact path you must take, ensuring that higher courts are not paralyzed by cases that lower courts are perfectly equipped to handle. Moving down to our essential field, what exactly is the principle of judicial hierarchy? It provides the appropriate forum for a case. It provides that the appropriate forum for a case is the court lowest in the judicial hierarchy. As we learned previously, the Supreme Court, the Court of Appeals, and the regional trial courts all share concurrent jurisdiction to issue extraordinary writs like certiorari, prohibition, and mandamus. However, this commonality does not give the petitioner unrestricted freedom to choose whichever forum they want. You cannot bypass the RTC and say and go straight to the Supreme Court. You must start from the bottom up. The hierarchy guides litigants on the proper venue for appeals and serves as the general determinant for extraordinary writ. Continuing with our essential pillar, why does this rule exist? The Supreme Court is simply not equipped either by the structure or by rule to receive and evaluate evidence in the first instance. That is the primary function of the lower trial courts. The hierarchy operates as a constitutional filtering mechanism, preventing inordinate demands of the Supreme Court's time so it can focus on its fundamental task. Because of this, compliance is a constitutional imperative. You violate the hierarchy of courts by filing directly with the Supreme Court without a valid reason, your petition will be dismissed outright. Now we reach the elemental principle. Is the doctrine of judicial hierarchy an ironclad rule? No. The Supreme Court allows direct resort to it under highly exceptional grounds. You can bypass the lower courts if there are genuine issues of constitutionality that need immediate attention. If the case involves matters of transcendental importance, or if it is a novel case of first impression. You can also go straight to the Supreme Court if you are reviewing the acts of a constitutional organ like COMELEC, or if it is dictated by the broader interest of justice and public welfare. However, as we will see in the next slide, even these exceptions have strict limitations. This brings us to a highly testable limitation. If you memorize one thing today, let it be this. The general invocation of transcendental importance is not a magic talisman that automatically excuses you from the hierarchy of court. The Supreme Court has clarified that direct recourse is allowed only when the issues presented are purely legal in nature. Remember, the Supreme Court is not a trier of facts. If your petition requires the determination of a factual issue, meaning you need to present evidence, witnesses, or documents to prove your point, the Supreme Court will refuse to resolve the question, regardless of how transcendentally important your case is. Factual questions must first be brought before the proper trial courts. Let us bring this down to the root level and see this exact limitation applied in the landmark case of Geus Samar versus Day013. Here, The government bundled the development of six regional airports into two massive bidding projects. The petitioner went directly to the Supreme Court via a petition for prohibition, arguing that this bundling was unconstitutional because it would create a monopoly and a combination in restraint of trade. The petitioner explicitly invoked the transcendental importance exception. Did the Supreme Court entertain the petition? No, the court dismissed it outright. While the issue was indeed important, the arguments against the constitutionality of the project were inextricably intertwined with underlying question of facts. To determine if a monopoly was created, the court would need to receive economic data, financial records, and expert testimony. Since the Supreme Court is not a trier of facts, the direct resort violated the hierarchy of courts. To wrap up our discussion today, here is a highly possible bar question that perfectly tests your understanding of the hierarchy of courts and the jus samar limitation. Let us read it. A group of environmentalists directly filed a petition for certiorari and prohibition before the Supreme Court against the DNR to stop a massive reclamation project in Manila Bay. They bypassed the RTC and the SAA, explicitly invoking the transcendental importance of the issue, claiming the project will irreversibly destroy the marine ecosystem. The DNR sought the outright dismissal of the petition, arguing that the environmentalist claims of ecological destruction are highly disputed and that the DNR possesses numerous scientific impact studies proving the project is safe. Should the Supreme Court dismiss the petition for violating the doctrine of hierarchy of courts? I will leave this question with you as your assignment. Apply what we just learned about whether the Supreme Court will entertain transcendental cases that involve disputed facts and scientific evidence. Draft your best beer-style answer, and we will reveal the suggested answer after 3 days. Before we officially end, let us look back at our guiding verse from Exodus chapter 18, verses 22. Have them bring every difficult case to you. The simple cases they can decide themselves. Just as Moses needed lower judges to filter the simple factual disputes so he could effectively dispense justice, our Supreme Court operates exactly the same way. It cannot function if every single dispute is dumped at its door. On a personal level, as you navigate your bar review, apply the same hierarchy to your study habits. Master the simple foundational rules first before you overwhelm your mind with the most difficult exceptions. Thank you for joining me on day 13. Keep up the momentum, and I will see you in our next